Thank you for joining us for the North Texas Coerced Debt Pilot Project Attorney Training. I'm going to cover Chapter 521 orders, what they are, and why someone would benefit from one, as well as the court process in order to obtain such an order. First, my name is Brittany Hightower. I'm a supervising attorney over program-wide units at Lone Star Legal Aid, where I lead the team that works with survivors of sexual violence. We handle a variety of legal needs for our clients, including protective orders, divorces, custody matters, evictions, Title IX complaints, and of course, consumer law issues. Previously, I worked as a senior staff attorney here at LSLA, an assistant attorney general for the Child Support Office, an assistant county attorney for the Williamson County Attorney's Office, and a senior staff attorney for Texas Advocacy Project. So a quick overview of what we're going to cover today. First, I'm going to go over the law itself, including why anyone would want a Chapter 521 order. Next, we will go over practical steps for preparing and filing a Chapter 521 case. And after that, I will review what to expect at the hearing. Lastly, we're going to discuss steps to take after the hearing to wrap up the case. So first, what are we talking about when we talk about Chapter 521? Well, we're specifically referencing Chapter 521 of the Texas Business and Commerce Code, which is the civil definition of identity theft and also governs the process for applying for a court order declaring someone a victim of identity theft. That order can be strong evidence that a survivor was the victim of identity theft. With the order, a survivor can now access the identity theft remedies in the alphabet soup that Carla covered, or at least make them a little easier to access. The remedy for coerced debt is the dispute with the credit bureaus or the creditor themselves. The vehicle is the 521 order, or think of it as the muscle that's backing up the dispute. So this is the entire law. It's very short. It's pretty simple and straightforward. I encourage everyone to go read it before getting started, but here we're going to go over it step by step. So the first section, section 521.101, governs standing. Who has standing to file an application for a Chapter 521 order? That's any person who has been injured by someone else's violation of section 521.051 of the Texas Business and Commerce Code. So necessarily, we need to go look and see what .051 says. This section is the official civil law definition of identity theft. It says that a person may not obtain, possess, transfer, or use another person's personal identifying information without their effective consent, and with the intent to obtain a good, a service, insurance, an extension of credit, or any other thing of value in that person's name. So now we need to know, what is effective consent? This same section defines what effective consent is not. Consent is not considered effective if it is induced by force, threat, fraud, or coercion. Effective consent was only added to that definition in 2021. So prior to that, you could only utilize this to obtain an order showing that you're a victim of identity theft if the consent was obtained by fraud, if you didn't know about it. So going back to look at the section on standing, Chapter 521 also grants standing to anyone who has filed a criminal complaint or a police report alleging identity theft under Texas criminal law. However, because of that change in 2021, a police report is not mandatory. A survivor can provide other evidence of identity theft in order to obtain a Chapter 521 order without having to go to the police in order to make a report. So Section 101 also covers the remedy. What is the goal here? Chapter 521 creates a cause of action whereby a survivor can file an application requesting an order declaring that they are a victim of identity theft. Chapter 521 is just an action for declaratory judgment. The law here does have a presumption. Section 102 specifically says that if the offender or if the abuser has been convicted of identity theft under criminal law, then Section 521.101 is going to presume, the court needs to presume, that the survivor has been a victim of identity theft. But this is very rare. If that has happened, you're going to want to obtain certified copies of the abuser's conviction to use as evidence in the 521 case. If the disposition records don't specifically name the survivor as the victim, I also like to obtain copies of the initial charging documents to show who the victim was. However, this is going to be extremely rare for the abuser or imposter to be convicted, so don't expect to see this in many cases. Section 103 governs the order. If the court finds by a preponderance of the evidence that the survivor has been a victim of identity theft, either under the civil definition in Chapter 521 or that criminal definition, then the court shall issue an order declaring that person to be a victim of identity theft. Section 104 says that the order is required, any order issued under Chapter 521 is required to be sealed, and all information contained in this order is to be kept confidential. If you've handled civil litigation before, you might be wondering about how Texas Rule of Civil Procedure 76A plays into this. Rule 76A governs the standard for sealing court records and says that no court order or opinion issued in the adjudication of a case may be sealed. However, Rule 76A also says that court records may be removed as permitted by statute or rule. Because Section 521.104 specifically requires the order to be sealed, this is not a conflict with Rule 76A. So, of course, there's probably some people right now who are very worried that someone may apply for a Chapter 521 order, not because they were truly a victim of identity theft, but because they just don't want to pay legitimate debt that they actually accrued. Not to worry. Chapter 521, Section 105 authorizes the court to vacate any order issued under this section at any time if the court finds that the order was based on a fraudulent misrepresentation, meaning somebody actually lied, or a material misrepresentation of fact. Let's say the survivor believed this genuinely and did not lie in court, but it turned out not to be true, and that fact was material to the issuance of the order. So now we're going to cover what the practical steps look like. First, you're going to plan and prepare the case. Then you're going to draft and file the application. You're going to set the hearing, give the required notice to anybody who's entitled to it, conduct the hearing, and then afterwards obtain orders and close the case. So first, we're going to cover the case planning worksheet and how you can use that in order to plan for the case. So here we've created the case planning worksheet for you to use as a tool to guide you through the process of helping the client tackle coerced debts and document the outcome of each step. So first, we're going to start with the coerced debt inventory. Here you can see we have created all these different fields with account name, number, type of account, status, etc. You can log coerced debts that show up on the credit report or other sources into this inventory. You're going to want to pay very special attention to the type of debt and the date that it was incurred. Was the debt incurred before September 1st, 2019? It may not be counted as identity theft if the survivor knew about it but was coerced to take out the debt. However, if the debt was incurred between September 1st of 2019 and August 31st of 2021, it may still be identity theft, but the survivor may have to file a police report. A debt that was incurred at any point in time but may be considered credit card abuse or debit card abuse, it may not depend on the debt. This can get a little tricky, so if you need some help reviewing this, feel free to reach out to us. We're going to move on to the next tab, the case plan. Here you can create a case plan with steps to take before the Chapter 521 hearing, such as disputing coerced debts that appear on the client's credit report. You want to detail the specific items that you will need to address at the hearing as well. So that section here is prior to the hearing, things you want to address down here at the hearing. You're going to want to detail specific items such as accounts, names, addresses, or purchases that were the result of identity theft. And then lastly, here you want to make any notes about any follow-up you will need to do after the hearing, such as submitting additional disputes, providing the client with documentation of the dispute outcomes, or referring the client to other providers if necessary. Next, we have the disputes tab. Here you will document each dispute. Here you will document each dispute that you help clients submit to the credit reporting agencies or creditors. So again, we have a section here for account name, numbers, type of account, amount of identity theft or other harm, whether the responsibility was individual or joint, type of dispute, whether you send it in prior to the 521 hearing, and then scrolling over, documentation of any sort of response received and what action, if any action, was taken by the agency that you sent it into. Lastly, we have the case notes here where you can document any additional concerns about the case. So for example, specific notes about clients' overall needs and goals, any challenges related to the dispute, such as mail returned, or if the debt was still affirmed after the dispute, and then other possible problems here, such as safety concerns, issues gathering evidence, ethical concerns, difficulty communicating with the client, maybe even if you need an interpreter, just things here to help keep you want to help keep in mind. So now we're going to go back to the presentation. So now we're going to take a look at the application. First, jurisdiction for filing the application is going to be in district court. Venue is going to be the county where the survivor lives, where the imposter lives, or where the acts occurred. Because we're focusing specifically on North Texas, this is either going to be Tarrant or Dallas County. The burden of proof is going to be preponderance of the evidence, so the low standard that we typically see in civil court. And then lastly, discovery is at level 2. This is just a result of not meeting the requirements for level 1 or level 3 discovery. There really should not be any discovery in this because there's no other party to the case. There's no one to request discovery from your client, and there's no one for you to request discovery from. So a word about personally identifying information. The court is going to need to see personal identifying information to be able to grant the Chapter 521 order. Because the application is a public document, you will want to draft the application in a way to reduce the amount of personal identifying information that you need to include. To the extent you need to add personal identifying information, you're going to want to redact it using an X in place of each omitted character. So for example, if the client's social security number is 123-45-6789, you would redact that to XXX-XX-6789. Texas Rule of Civil Procedure 21C requires that you may retain an unredacted version of the application while the case is pending and for 6 months afterward. So if the client knows the abuser was the imposter, then you'd need to include that information in the application. So for example, if the abuser threatened your client with a gun, if she didn't go to the car dealership to sign for a car loan, then clearly she knows who the imposter is. However, a strong suspicion does not equal actual knowledge. You do not have to, and you should not name the abuser as the imposter if, for example, the client discovered surprise credit card on their credit report and, quote, knows it was the abuser because, quote, who else would have done this to me? You do not want to name someone an imposter without having actual knowledge that they were the imposter. And likewise, you don't want to create a situation where you have to notify a dangerous abuser of the hearing when it's not necessary to do so. So here's our sample application, but like the case planning worksheet, I'm going to go over the application step by step. So now we're going to walk through the application. We've highlighted here in red the different sections that you're going to need to replace with your client-specific information. So clearly here you're going to put in the client's name in these 2 spots, put the client's name here, correct this to their appropriate pronouns, whichever ones that they use. We're going to scroll down here. Again, here, this is where you're going to put in the client's name. And then scrolling down to the facts, this is where you're going to put in the detailed information. So you have 2 options here. If you know who the imposter was and you know for sure that it was the abuser, you're going to use this first paragraph. You're going to explain that the client was in a relationship, whether they were married, living together, long-term dating relationship with an abuser imposter, and then put the abuser's name here. Or in the alternative, if you don't know for sure who the imposter is, you're going to use this second paragraph, where it specifically says applicant client's name is a victim of identity theft and does not know the identity of the person who allegedly used their information. And then you're going to want to state the specific facts of how the victim learned of the identity theft. So for example, if your client only discovered the identity theft when they pulled their credit report and saw surprise charges on there or surprise accounts on there, you're going to want to explain that. If they got served with a citation or summons for a debt that they didn't know anything about, that's where you're going to explain that. Again, this is where you're going to put the specific personal identifying information. But again, this is a public document. You want to be limited in what you put here. So for example, you can say specifically that they used their name, their social security number, they used their address, their mother's maiden name, but you don't have to name those specific facts. You're going to wait and do that at the hearing and include the actual information in the order. So for example, you would just say social security number here instead of saying social security number 123-45-6789. Here's where you're going to explain specifically if the police report was filed, you want to include a statement that the applicant did file a complaint with this particular police department and attach a copy of that police report as an exhibit. If they've completed identity theft affidavits, again, you're going to want to attach these as exhibits. If there's specific accounts that were compromised, so for example, let's say it wasn't just a particular purchase on an account that the client, that it actually is the client's account, but specific accounts, you're going to want to go through and detail all this information here about the accounts, and you're going to pull that, again, information that is going to come from the credit report that you've placed in the case planning worksheet. And then again, if down here, if the person has also filed a police report or the client has also filed a police report, you're going to want to include this last language here, explaining that they've been a victim of identity theft, both under Chapter 521 as well as under the Texas Penal Code. And then that's the application. We're going to go back to the presentation. So let's talk about filing fees. Filing fees for these cases can be several $100s. Most likely, your client can't afford to pay that without making some serious sacrifices. Texas Rule of Civil Procedure 145 prohibits the court from charging any fees associated with the case if your client completes and signs a statement of inability to pay. So now I'm going to walk through what the statement of inability to pay looks like. So this is the official statement of inability to afford payment of court costs or an appeal bond that's been promulgated by the Texas Supreme Court. You're going to file this at the same time as you file the application. We're going to go through this step by step. So of course, if you're filing it at the same time as your application, you're not going to have a cause number, so you leave this blank. Here you're going to put the style of the case, which will be in the matter of client name. And again, leave this part blank. You're not going to know the specific court number. You're going to check the box for district court because that's where jurisdiction is, and then put in the county where you're filing. So moving to the next page, you're going to put your client's information here. Again, be sure and check in with them about privacy and safety concerns. This will be a public document, so if they have concerns about their address being included in a public document, their phone number or their email, I think it's okay to go ahead and put confidential here. I do this all the time, as long as you're the one representing them and the court can communicate with you. The purpose of this is to make sure that the court has a means of communicating with your client in case they need to challenge this. So moving forward, you want to include any dependents that your client has. I use initials for minor children, put their age, and then put their relationship here. So this specifically says, are you being represented by legal aid? This is not something that you're going to want to check because you're not working for legal aid. This is a provision in the rule that specifically says if someone is eligible for services through a legal aid organization or another grant-funded organization, then they're going to be determined to be eligible, and so the court can't challenge those. So they're going to want to check, I'm not represented by legal aid. Here's where you're going to go through and check if they receive any public benefits. Most people with their low income are going to be receiving food stamps, and the kids are most likely going to be receiving Medicaid. So make sure and ask about those, or CHIP or Medicaid. The rest of these are a little bit less common, but it's still worth asking about each one individually. The rule requires you to attach a copy of any proof that they're receiving benefits. I've never had one of these challenged for not including them, and a lot of our clients, especially if they're in a transient state, if they're still in shelter, if they're trying to find housing, may not have that documentation. But if they are receiving food stamps or Medicaid, they should be able to get their award letter off of the app or off of the website, and you can help them do that. So the rest of this is kind of like a little budget worksheet. And I explain it that way if anybody has experience with this. This is where you're going to document what their pay is. Remember, this is take-home pay. Most of the time when somebody's asking for their income, they're looking for gross, but this particular form asks for their take-home pay, so pay after taxes. And include their total income. Again, you want to include income from all resources. If they're receiving any sort of cash benefits, or things like food stamps that has an actual dollar amount, you want to include that here. If they're receiving money from other people in the household or other support system, you want to document in all these places. And then at the bottom, you're going to total up what the total amount of income from all other sources is. Then here's where you talk about the client's property. So even if it's going to be something exempt, like a vehicle used for transportation or a house that they live in, you still need to document it here. But that's also minus anything that they owe on it. So for example, I have a client that's driving a paid off 2000 Ford truck, then we're going to put the total value of the truck. But if they're driving a 2018 Hyundai Elantra and they are still paying on that vehicle, we're going to look at what the total value of the vehicle is, and we're going to subtract what they still owe on that loan. And then add up the total value of their property here. And then you're going to go through what their monthly expenses are. I go through these step by step with them, and I really ask them to think about it. Because when you add up their total monthly expenses that they are actually paying here at the bottom, it should be roughly equal to what their monthly income is. Because if it's much higher, then that means some of those bills aren't getting paid, and so you shouldn't include this here. If it's much lower, inevitably they forgot about something. Usually what I'll have happen is they'll think of something that they have to pay twice a month, and they'll consider it, they'll only think of it once. Or they'll forget to cover gas when it comes to transportation expenses, or they'll forget about periodic expenses such as buying clothes or school supplies. So I kind of like to go through and sort of remind them, do you have a cell phone? Do you have to pay car insurance? You know, how much do you pay for gas? Do you have a washer and dryer at home, or do you have to go to a laundromat and pay to wash your clothes? So it should be roughly equal to what they earn each month. And then lastly, this is the section where you're going to include any sort of debts that they have out there, but they're not necessarily able to pay, to show that they're already making sacrifices in order to meet their daily needs. There's no room for them to make sacrifices in order to pay the filing fees. And then lastly, be sure to check this box to show that they cannot afford to pay the court costs. When it comes to signing, there's two options. They can either fill this out as an unsworn declaration, so they don't have to go before a notary, but this is where they are required to include their address, their date of birth, this information. Again, for privacy reasons or safety reasons, if your client does not feel comfortable doing this, you're going to want to use the second option where they have to sign before a notary. And if you don't have experience using a notary, they cannot sign and then have it notarized. They need to wait and sign in front of the notary. So now let's go back to the presentation. So now we're going to cover e-filing. When you're electronically filing this, using whichever system you prefer to use, you're going to file this as case type, as other civil. The style should be in the matter of client name. There's no defendant, so you're just going to leave that blank, or put in none or unknown. And then the description should be identity theft. And lastly, under relief sought, you're going to select declaratory judgment. So you are required to provide notice to all creditors and, if known, the imposter/abuser. This is a big reason why you don't want to name the abuser as the imposter unless your client knows for sure that is who stole their identity. So notice is not the same as service of citation. You do not need to request a citation or other formal service instrument under the Texas Rules of Civil Procedure. You just need to send notice of the hearing to the creditors and, if necessary, the imposter. You can send this notice by email, mail, fax, etc. Just be sure to attach a copy of the application and save documentation of service. So save the sent email, save the fax confirmation, just so you can provide documentation that you met this requirement. So here's a copy of our sample order. It's included in your resource materials, but just like the case planning worksheet and the sample application, I'm going to go over the order step by step. So now we're going to take a look at our sample order. So just like the application, we have all the fields that you're going to need to replace highlighted in red. So again, replace this with the client's name. Make sure you fill in the cause number, the specific county that you're filing in, and the specific district court. Put your name here as name of the attorney. Again, replace this with the client's name. And here's where you're going to put in the specific information that we were going to redact or try to avoid using in the application. So we're going to say that the identity of the perpetrator, if we know, or that the identity of the perpetrator is unknown. And now we're going to go through all the specific information that was misused by the identity thief. So client's name, address, date of birth, social security number, driver's license, any other personal identifying information. You want to list all the specific numbers and information that was misused here. And that's why we have the order sealed. Then we're going to go through and highlight all the specific accounts that were fraudulently opened and compromised as a result of identity theft. So you're going to repeat all of this information for any additional accounts. And here's where you're going to want to be specific. So for example, if the client had a Chase credit card that they opened prior to this relationship, it's a valid credit card, but the abuser misused it and racked up charges on this that were coerced debts. This is where you're going to identify those specific purchases, those specific items, the specific dates, and show that it's not just the account, it's not the account that was compromised, it's those specific charges that were compromised. And then lastly, at the end, you're going to replace this with the client's name. And then this is where the judge is going to sign. So now we're going to go back to the presentation. So now let's cover preparing for the hearing itself. First, you want to review anything that will be submitted to the court with your client. That includes the application, the proposed order, any exhibits, and your testimony questions. Prepare your exhibits in advance. You want to print them in a legible format. Label each exhibit with an exhibit sticker. If you don't have exhibit stickers, you can write Exhibit 1 or Exhibit 2 in bold black marker on a clear white area of the first page of the exhibit. Make sure multiple page exhibits are stapled, not paper clipped. Sometimes things can get misplaced or misorganized, so it's better just to kind of have them all together. Your client's testimony is going to need to focus on the critical facts. So, of course, the client's name and other personal identifying information if necessary. The venue, just ask the client whether they live there, if the imposter lives there, the acts occurred there. Specific information for each coerced debt, who the creditor or the furnisher was, account numbers, specific charges if that's what the client is disputing, who the imposter was if it's actually known, and really show that the imposter had the intent to obtain a goods, service, insurance, extension of credit, or any other thing of value. This is usually pretty easy to show in the fact that that person did obtain this and the client didn't really receive any benefit from it. Show that it was in the client's name and the specific details of the lack of consent or the effective consent. So for example, what was the force, the threat, the fraud, or the coercion that resulted in the client being either forced to take this out or this debt being taken out without the client knowing about it. So about how to prepare testimony questions. You can either make hearing notes, like a little outline, or actually list out your specific questions. It just depends on what feels best for your style. I prefer to make a clear list of questions, starting with, what is your name? And I can easily alter my written questions in my head or skip questions if my client's responses require me to make modifications. So for example, I may intend to ask my client first when they separated from the abuser and next when they discovered the coerced debt. But when I ask the first question, they may respond with, well, I left and moved in with my parents last May, right after I found a box of credit cards in my name that I had never seen in his closet. So therefore, she's already addressed both those questions, and I know I've met that element, and I'm going to move on. Other attorneys often feel stilted or stifled by sticking to a list of questions and just prefer to create an outline of issues or elements that they need to prove. Regardless of your approach, I strongly recommend printing or writing out your guide for testimony and making sure to check off each question or element after you get the necessary evidence on records. And then after you prepare all this, you want to make sure and print and add all these documents to your presentation binder. So let's take a look where I'm going to review some of our sample questions and the resources. So these are some sample questions that are included in the resources for you. So for example, starting with asking the client to state their name for the record. Are you a victim of identity theft? Did another person use your personal identifying information without your permission? Sometimes because clients get nervous in court or they just sort of feel intimidated, you might run into situations where they just draw a blank. I've literally had a client pause and kind of forget her name for a second. So sometimes it can help to rephrase things. So if you ask, did another person use your personal identifying information without your permission, and they freeze and are kind of having a moment, you can reframe that and use more layman's terms. Did another person use your name and social security number? Did they use your birth date? Things like that. What personal identifying information belonging to you was used without your permission? Do you know who did this? Do you know how the thief got your information? This is really important to prepare the client and let them know, don't guess. Don't say, well, I think it was so-and-so. Let them know they need to answer the question very specifically. Do you know? If they don't know for sure, the answer is just no, and they need to leave it at that. When was this incident? What did the thief do with your information? You want to authenticate and admit documents. So for example, if one of the exhibits you're going to enter is a delinquency notice from a car loan or a past due statement on a credit card bill, you're going to show that to your client and say, I've handed you what's been marked as Exhibit 1. Do you recognize this? And they're going to say yes, because you prepared them. And then ask them to describe what it is. And they're going to say, this is a credit card statement. If they don't give the full details, you can ask them, what's the date on this credit card statement? Who does this credit card statement come from? And then after that, offer to admit it as an exhibit, or ask the court to admit it as an exhibit. So moving forward, ask the client, how did you find out this happened? You want to specifically ask them, did you ever give permission for this person to open this account, use this card, incur these purchases using this card? You want to go through the specific account numbers. If there's a lot of accounts there, you can ask them, were these the account numbers that are listed in the order? Do you recognize these? Or if it's just a couple, you can ask them specifically what the account numbers were. I recommend doing the former simply because one, it's kind of intimidating in court, and two, a lot of people are not going to know their specific credit card account numbers. I couldn't tell you mine. Then you want to ask the client, did you take this specific action? Did you do this? Did you write the check? Did you open this account? Did you use this card to make these purchases? Again, specifically ask them, did you authorize anybody else in order to do these actions? You want to ask what the total amount of financial loss was. And again, this is where preparation is important. You're going to be able to review this ahead of time and have all these numbers put together. And prepare that client to be able to ask this question. Again, they may have a brain freeze in that moment and forget the specific number. So you can ask the leading question, was the total amount of financial loss X? And then they can say yes or no to that. You can ask them if they reported it to the police. Did they report it to the creditor? You want to ask about any attempts that you've made to dispute this or address this beforehand. So have you disputed this directly with the creditor? Have you disputed this with the credit reporting agencies, etc.? Lastly, ask if you've gotten any help from them, if they've responded appropriately. And then finally, your ultimate question always is going to be, are you asking the court to issue an order declaring you to be a victim of identity theft today? So let's go back to the presentation. So for the hearing, you're going to prepare the client, you're going to prepare your questions and exhibits in advance, and then go through the testimony in order to establish the facts. It really shouldn't take very long. But remember, the goal is also to help the client tell their story. You want to allow them a little bit of space and a little bit of latitude to talk about what happened to them in the way that they need to. This is just as important as it is about winning the case. This is really them taking some ownership or regaining some power back after it's been taken from them. Just a couple of other little tips too. I really encourage people to bring anything if you tend to need it. So think tissues, lip balm, eye drops, water, a small snack, etc. Of course, you cannot snack in the courtroom, but I've found that sometimes clients are so nervous or so overwhelmed that they don't eat breakfast. And then if we end up having to sit through a long docket that day, or if judge is delayed for any reason, it can just exacerbate their nerves. And so we can step out and offer them a snack, offer them a small water, something to that effect. And again, also for you as well, it can make it a little bit easier just to sort of have the things that you need there. So moving forward after the hearing, you're going to want to obtain certified copies of the order before the order is sealed. You're going to want to make sure that you have enough copies for the client and each creditor, bill collector, or the credit bureau that you're going to be disputing with before the order is sealed. Because once the order is sealed, it is very difficult to go back afterwards and reopen it in order to get additional copies. So more copies is always better. You're going to want to review the client's dispute letters. Just make sure all the required information and elements are in there. And that they're addressed to the right people. The letter's going to be signed by the client, but you will be the ones mailing it out. So then mail the dispute letters out, review the end of process with client, explaining what your role was. Now that your role is done, you're mailing out the dispute letters for them. They should be receiving a response at their address. And if they have any more issues, that they're welcome to follow up back with us. So this is the legal expert team. That's me, Ms. Carla Sanchez-Adams, and Ms. Paula Pierce that all went into building this presentation and building all this information here for you. Carla and I are both available as resources for you. Thank you for doing this really important work, and feel free to email me with questions. This is my contact information here.